everybody. Thank you again for joining today's training, Know Your Rights training for business owners and employers. Today's training is hosted by Seattle Office of Immigrant Refugee Affairs, Seattle Office of Economic Development, and Seattle Office of Labor Standards. My name is Gina Yang, and I'm the Workforce Program and Policy Specialist at Seattle Office of Immigrant Refugee Affairs. I'll be your facilitator for today's webinar. Before we get started, please look at the bottom of your screen. We can go back one slide. Great. And please click the global icon that says interpretation and click English if you're here to listen English or the language that you requested through our registration. If you're on your smartphone, next slide, you may need to click more to find interpretation option, and there'll be you'll be able to hear your interpretation language. So next slide, please. Today's agenda, we'll hear information and resources from the Seattle City Department. Afterwards, we will have a presentation from our trainers, Adam Boyd, Brianne Johnson from Gibbs Houston Pauw. They'll be covering topics including federal enforcement, I-9 audits, and best practices for employers. We will answer questions from the audience after all the presentation. Next slide. Please be aware that this training is open to public and will be recorded. Please do not share any personal and sensitive information. Throughout the training, if you have any questions, please click Q&A at the bottom menu and submit your question in the box. Please ask questions that are not case-specific. Also, please do not share any personal information. Next slide. Before we hear from our city department, I would like to remind everyone that Seattle is a welcoming city. Everyone has the right to live with dignity and be safe in our city. City of Seattle does not ask about immigration status and serve everyone regardless of status. City of Seattle also does not cooperate with immigration enforcement, but does not prevent or impede it. For information, immigration enforcement is a federal matter. Next slide. On January 29th, 2026, Mayor Katie Wilson signed an executive order prohibiting the use of the property that is both city-owned and city-controlled for federal civil immigration enforcement activities, which includes staging, operations, or proceeding. City properties include city parking lot, parks, storage facilities, and the Seattle Center. However, the city cannot prevent ICE and federal immigration enforcement activity on private property. Due to the executive order, city has posted signs stating that the property shall not be used for civil immigration enforcement, staging, operations, or proceeding, and not be accessed by federal agents without a warrant. Private property owners can also post these signs at their own discretion and assume any potential legal risk. These signs are available at Stand Together website, and they're available in 18 languages. Please take a look at the chat to access the website. Now we will have Oksana Bilobrand, Legal Defense Program Policy Manager from the Office of Immigrant Refugee Affairs, to share about our legal program and resources. Next slide.
Thank you, Gina. I'm Oksana Bilobrand with the Seattle Office of Immigrant and Refugee Affairs, and I'm here to do a very quick introduction to the kind of work that our office has been doing here in the city of Seattle. Next, please. The mission of our office is to improve the lives of immigrant and refugee communities in the city through the many programs we manage and fund here in our office. Next. Those programs include several legal program services, such as Legal Defense Network, that provides free, full legal representation to people who are facing removal proceedings. Also, naturalization assistance programs. We have what we call Ready to Work program, which provides basic adult education, including English as second language and job readiness skills. We have immigrant safety and access network programs. We provide also emergency housing to recent arrivals and asylum seekers. And we administer language access program that provides interpretation as you're able to enjoy it, some of you today on this webinar. Next. I want to draw your attention to the program which we call Legal Defense Network. This is a very valuable program that you might want to be aware of in case you have family members or people who work for your businesses or for your organizations that might be facing deportation. This program is open to eligible participants who are low income, are Seattle residents, workers, or students, or have removal case in Seattle Immigration Court. And if they have certain immigration status that puts them at risk of removal. The program offers absolutely free, full legal representation. So you get to work with the lawyer one-on-one who's going to be able to submit various applications and motions in immigration court, both in detained and non-detained settings, and filing all the applications from the beginning to the end of your case. And on the screen here, you see the list of providers. So if you have somebody who might be eligible for the program, we urge you to connect with the providers, see if you can qualify for those services. Next. We also offer limited legal services through a program that we called Rapid Response, and that includes legal education such as Know Your Rights trainings, limited legal services in the form of legal advice. So eligible clients, again, those who have connection to Seattle.
Excuse me, hello.
Am I speaking
I'm so
too fast?
Please continue, Oksana.
Okay, I'm sorry. I'll try to speak slower. Thank you for reminding. So we offer limited legal consultations, Know Your Right trainings, and also family safety planning. So in the event that immigrants might be at risk of detention or removal, and if they need to get their affairs in order, they should contact one of the partners whose logos you can see here on the slide. Next slide, please. So for more information, you can read it here on the slide, but I've already covered that we provide legal consultation, Know Your Rights, and family safety planning. We also support an organization called WISN that offers hotline services to report ICE activity in your area. Next. We urge you to go to our website for more information. There are 2 links in the chat already. Take your time and find out how you can contact our contracted partners and legal service providers. We are also present on social media, so feel free to follow us on the social media so you can learn about updates coming from our office, new funding, and services. Thank you. Back to you, Gina.
Thank you, Oksana. Now we will have Michael Wells, small business advocate from the Office of Economic Development, to share about their business support programs. Thank you, Michael.
Hi, everyone. Thank you, Gina. I'm Michael Wells. I'm a small business advocate with the Office of Economic Development. I'm a former small business owner myself, and I'm telling you about a couple of programs today that might be of interest to you. My contact information will be available at the end of this slide. If you have any further questions, I'm happy to follow up. First, the general eligibility to participate in our programs. To be eligible for all small business support programs, businesses need to have a valid City of Seattle business license, operate within the Seattle city limits, and be a for-profit and independent non-franchise business. Each service and program may have additional eligibility requirements, but this is the baseline for any of our program participation. We have a commitment to equity, and many of our programs prioritize women and minority-owned businesses. Services are open and available to all. We never ask about immigration status. So services are available in multiple languages. You'll see some of them listed below: Amharic, Chinese, Korean, Somali, Spanish, Thai, Vietnamese, and many more. Next slide, please, Tina. First, probably our most popular program is our Accounting and Business Consulting program, which we call ABC. The program supports Seattle-based businesses and nonprofits that want to grow. It's available to both established businesses and new businesses. And each eligible business receives up to 10 free hours of one-on-one consulting on the following topics. So accounting and bookkeeping is one category, marketing and branding, another category, business development, credit and debt management, and loan support. It's a very popular program with businesses. It's a lot of free consulting hours that are available to businesses in Seattle. So we're very proud of this program. Next. The Small Business Legal Assistance Program, which is what I manage at Office of Economic Development, offers consultations to address legal issues associated with owning and operating a small business. Free counseling and legal workshops include individual consultation with legal professionals, corporate and intellectual property education, commercial leasing, landlord and tenant resources and education, business-specific legal reference materials, legal workshop and resource development on issues such as commercial leasing, intellectual property, employee and labor relations. Our two partners in this work are the Seattle Public Library, their Library to Business program, and Communities Rise, a nonprofit that serves legal needs with an emphasis on minority and women-owned businesses. Both of these nonprofit partners tap into a pro bono network of lawyers who are doing volunteer service to help small businesses in our communities. So, and again, my contact information is here. This, again, is available for both established businesses and new businesses. Next. Our Back to Business program is something you may have read about in the papers. It's also a very popular program. It supports small businesses impacted by vandalism and property damage, and it offers help through two reimbursement models. The first is the Storefront Repair Fund, grants to help businesses get reimbursed for the cost of fixing damages for vandalism or other property damage. Some people refer to this as the Storefront Repair Grant. Eligible businesses can apply up to 3 times per year, one grant per incident, and each grant can cover up to $3,000 in reimbursement. So a broken door, a broken window, a gate, damage due to vandalism and property damage all fall under the Storefront Repair Grant. The Storefront Security Grant is a little higher amount. It is to reimburse business owners to cover the cost of improving their security. So it requires a security assessment by a crime prevention coordinator through the Seattle Police Department. They will come out and walk your business with you and talk about where you might improve security. That could be landscaping or lighting or other things. And then eligible businesses can apply only once for this one. And the security grant can cover up to $6,000 in reimbursement. Both of these are reimbursement models, so the business does have to pay first, and then we reimburse them. And we realize that can be.
Michael, if you can slow down a little bit, it's a lot of information happening at the same time. Yeah, thank you.
Certainly. Apologies. Thanks for the reminder. So the security grant can cover up to $6,000 in reimbursement. So those are the two pieces of the Back to Business grant. Again, a popular grant. And you've all read news stories about broken windows and doors, and we want to help on that front. So this is the grant that does that. And then next. So here's our contact information. Any questions about these programs or any other small business programs available, my information is here, both email and phone, as well as Philip Sitt, the Small Business Navigation Manager. So feel free to follow up with either one of us. And that's the end of the Office of Economic Development presentation. Thank you, Gina. I'll turn it back to you.
Hi, everyone.
Oh, thank you, Michael. Now we're going to have Star Berry, Labor Engagement Specialist from the Office of Labor Standards. Go ahead, Star.
Hi, everyone. Thank you for joining. My name is Star Berry. I am an educator. I work for the Office of Labor Standards. Our mission is to advance labor standards through thoughtful community and business engagement, strategic enforcement, and innovative policy development with a commitment to race and social justice. Like I said before, I'm here as a part of the outreach and education team. Do you know that the office is mandated to enforce Seattle's 16 labor laws? We offer multiple services for businesses and workers to encourage labor standards compliance. The Business Outreach and Education Fund, or BOEF, provides resources for businesses. The office's outreach team provides quarterly trainings. Please do not hesitate to reach out to us and request a training. Outreach and engagement specialists like me offer technical assistance and training. If needed, we can also connect you with other offices and resources when they are available. Next slide, please. Here is an image of our website. You can reach us on our website by going to the Employer and Hiring Entity Resources page, and someone will put the website in the chat in a moment. Here, you can reach out to us by sending us a message online, or you may call us at 206 256 5297. It's been a pleasure to share our resources. Have a great day. I'll turn it back to you, Gina.
Thank you, Star. For now, our main speakers, Adam Boyd and Brianne Johnson from Gibbs Houston Pauw, will be presenting and providing information for the business owners and employers. Next slide. This training is open to the public and will be recorded. Just a quick reminder for everyone. Please do not share any personal and sensitive information. Only ask non-specific questions. Throughout the training, if you have any question, please click Q&A at the bottom menu and submit your question in the box. We will do Q&A at the end, so you can ask questions then as well. Adam and Brianne, the floor is now yours.
Thank you, everyone. We're going to get our presentation up and running really quickly. And we're going to try and speak slowly and or take pauses so that the translation can keep up with us. All right. So I'm Adam Boyd. I'm the managing partner at Gibbs Houston Pauw, and I'm going to be co-presenting this with Brianne, and I'll let her also introduce herself.
Hi, everyone. Thank you so much for having us today. My name is Brianne Johnson, and I am one of our senior attorneys working with Adam at Gibbs Houston Pauw. We're looking forward to sharing this information and answering your questions. Is it okay if I kick it off, Adam?
Yeah, go ahead.
All right. I am going to start with a quick roadmap and overview of what we are going to talk about today as a big picture. So the primary point of our presentation is to talk about an Immigration and Customs Enforcement, or ICE, as you'll hear us call it, raid. So what to do, what happens, what it looks like when immigration shows up at your business, if, hopefully never, but if. We will also talk about the various rights that you have as a business owner, and a little bit we'll touch on your employees, their rights. We'll talk about best practices, tools, how to build things to think about in building a response plan. If time allows, well, we will also talk about a defensive I-9 audit. So if immigration comes in to audit your I-9s, if we have time, we'll talk about some affirmative I-9 tips and best practices and things that you can do in advance. And then we'll make sure we have time for everybody's questions.
All right, so I just want to give everyone a preview that this is a lot of information to cover in not a lot of time. And so if we do not get to everything, I encourage you to look at the materials that have been posted online. I also want to make everyone aware that we will be giving a second presentation that focuses more squarely on workers' rights. And so if we can limit questions about the employees' rights during this presentation, we would greatly appreciate it. So what Brienne told you we're going to start with is, what is an ICE raid? I'm sure everybody has a weird idea in their head of what it looks like and have read news stories or heard horror stories about, what happens. But basically, it can take a couple of different forms. So some people might refer to ICE coming and serving papers to look at your I-9s or your employment-based documents as an ICE raid. That's not typically the common phrase for an ICE raid. What we're talking more about is when ICE or other law enforcement officials working in conjunction with immigration officials come to try and arrest individuals they believe are unlawfully in the country. Usually, this would involve them attempting to gain access to an employment site, ask questions of both the employer and the employee. It may involve them serving a warrant, and we'll talk about that in just a little bit. And it may also involve people that don't wear identification that says ICE on them. We've seen much more collaboration with FBI, IRS, other quasi legal services that have agents are participating in these types of enforcements. And so it's not necessarily an I-9 service of subpoena. It's more when they come and want to try and arrest people. So why don't we go on to the next slide?
That's a perfect segue and piggyback of into who, if that bad day does happen and ICE decides to show up at your business, who's coming? What does that look like? And as Adam mentioned, there can be a few different agencies involved, and so they might say different things on their uniforms or security vests. Also might even be a plainclothes officer. Sometimes that can happen too. So the most probably common is going to be ICE itself, Immigration and Customs Enforcement. And usually they'll wear a vest saying police, ICE, something like that. Most often, most often whoever shows up looks like law enforcement or military. Often they can be masked. Often they're carrying guns or weapons visually. Sometimes it is the FBI, as Adam mentioned. And even, I actually didn't know this until kind of recently, but the IRS has a criminal wing. So even the IRS criminal officers can join in as well. So there can be a variety, I guess, of different types of officers who show up.
Uh, Piggybacking on that, one of the main goals of their initial arrival is to cause shock and panic, right? That's kind of the point of the masks. That's kind of the point of confusing, uniforms. ICE wearing something that says police is really not genuine, right? They're not typically who you would consider to be police. They're engaged in civil immigration enforcement. And so I wanted to caution you that part of their tactic is to be scary, but you don't need to fall into that. And that's what this presentation is about, is to sort of give you a preview of what you can expect, so that you don't fall into the typical traps of being alarmed and overreacting. So this is a quick outline of what you can expect. Usually there's an investigation, and you may or may not be aware of an investigation of what's going on. ICE typically doesn't want to show up to a large employer without knowing that there's somebody there that they can apprehend. And so they will often do surveillance, try and track the business hours, try and get a good idea of when people are coming and going, and see if they can identify who is in the facility by looking at people's license plates. Oftentimes you won't know about this, but sometimes we've had employers report, picking up suspicious vehicles or people on their external security cameras. Most of the time, this will go unnoticed. What you will notice is when they arrive, in force, usually screaming or usually trying to intimidate the employer into gaining access to what are typically non-public areas. Generally speaking, they will show up, try and tell you that you have no rights and that they're there to engage in law enforcement and that they need to get in to arrest illegal immigrants or some other form of, bullying. Oftentimes that will include unsubstantiated threats against the business owner about how you may be liable if you don't allow them into the facility. These are lies. So I just want to encourage you to remain calm during this period of time. The next thing is sometimes, well, we've labeled this as both actions that are done by ICE and actions that are done by the employer. The first thing that an employer should do is ask if there is a warrant. Okay? You really want to make sure that they have legal authorization to be in your space, because it should theoretically be a non-public space, even if you're serving the public in general. So your goal as the employer is ask what right they have or claiming to have to enter your place of employment. They should theoretically have some form of a warrant, and we will talk about that later. And if they do and have the legal authorization, they will come in and do what is permissible underneath the warrant. They'll conduct a search and whatever questioning they're authorized to do by a judge. If they identify anybody who is in the country without authorization or who has, is potentially deportable based on criminal convictions, it's likely that they will detain those people and transfer them to most likely the Northwest ICE Processing Center here in Washington. That's almost exclusively where our detainees wind up. Both during and after the raid, the employer's main job is to verify the warrant and be a documenter of what is happening. Immigration lawyers can only challenge these things under very rare circumstances and only if we have information about what happened. And so keeping contemporaneous records on a notepad, recording if at all possible, is always going to be one of the best things if ICE shows up with a valid warrant. And then as the employer, we would definitely recommend you reach out to a lawyer to protect you and your business after something like this happens, so that you're not opening yourself up to more liability based on what transpires.
So Thanks for that overview, Adam. Now we're going to go through kind of point by point and talk in more detail about each step of the lifespan of an ICE raid. And as Adam mentioned, the first step is the investigation that happens before an ICE raid ever starts. And truly, especially depending on the size of the business and the employer and the scope of the raid, these investigations can take weeks, can take months. They can involve getting warrants, doing surveillance, performing I-9 audits. There's a lot that goes into it, and really that's all that this is meant. I think all that you need to know is that the raids are carefully organized and planned events. When ICE shows up, in theory, they should be organized and they will have a bunch of information. They have to coordinate with different agencies. If they're planning to make arrests, they have to coordinate transportation. Like there's a lot of logistics that go into it. So they will be organized. We want you to be organized too to respond.
So the best thing, and we're going to repeat this over and over again, is to remain calm because the major tool that ICE has is catching people unaware and getting them to make mistakes. So, whatever helps you as an employer remain calm during a very stressful situation, we ask that you implement a policy that allows you to do that. So, keep a checklist, designate a direct point of contact who is supposed to take care of this type of stuff. Um, you know, make sure that you have take a second to take a deep breath before you just start jumping into action. Um, Panicking is always going to cause you to make errors, which is just going to make things worse. So, number one, check your check that the documentation is correct. So you're going to have somebody showing up in a mask, looking like a military officer, screaming at you. So you want to ask them to identify themselves, ask them to present a warrant or other documentation. If at all possible, you want them to present their credentials to show that they actually are law enforcement. Oftentimes, they won't present a badge or identify who they are or their name. Um, and then you would want to stop them at any point where there's a physical barrier between them and your workplace that they can't force their way through. Oftentimes, they will try and bypass this demand for a warrant by just pushing their way into unlocked spaces and just conducting arrests without you. This is not technically legal, but the more you can secure your own facility and prevent, somebody who's not authorized from accessing it, the better off you are. So keeping doors locked, having a designated public entry place that has, a door or glass or some sort of physical barrier between the remainder of your workspace is a really good tool. If you have a camera on the outside where you can, talk to somebody through the camera rather than just opening the door for them, that's going to help you in this process. But your main goal is to slow down a process that they're going to try to get done very quickly. We can go on to the next one.
Yeah, can I add a point to that? I
Of
think
course.
this is a good spot to reiterate just, and you said it, Adam, but the reality that this is a really scary moment. Um, it is a lot. There's very basic human responses to, of fear and panic to having masked, armed military walk aggressively towards your business. It's scary and it's really, really hard to stay calm and be logical and remember what to do when this happens. And so, one of the things that I think we can't stress enough is that it's really, really important to put a plan into place for what your specific business will do if this happens. Who is in charge? There should be multiple people. If you have multiple shifts, you need to be able to know what you're going to do if this happens, and you need to practice it. We practice fire drills, we practice all sorts of other things in the event of an emergency. This is that. So I would absolutely recommend making a plan, writing it down, and training people on that. So
Well, and don't overestimate the impact of having written down just what you're going to say. If all you're doing is reading off of a script, at least you're
yeah.
reading the right words.
Yeah, absolutely. Absolutely. I completely agree with that. Um, let's jump into the warrant and what is a warrant. We have a few slides about this, so you'll see a few different slides here. Um, I just kind of want to say at the most basic level, I want to answer that question of what is a warrant. It is a piece of paper, right? Issued by a judge or what's called a magistrate, which is another type of judge, issued by a court that grants authority to an agency, usually a law enforcement agency, to do something that they need permission to do, like access a private space like a home or a business, arrest somebody. So it's that's what it is at its most basic form. Whether or not immigration, ICE, needs a warrant depends on what they are doing and where they are going. So let's use our office of Gibbs Houston Pauw as an example. We are open from 9 to 5, Monday through Friday. We have a front door and a receptionist area. If ICE walks in at 9:01 into the receptionist area, that is a public space. We invite the public into our reception area during our open business hours. They don't need a warrant to come in to our public areas. Same with a restaurant or on the street or anything that's public. They do, however, need a valid, and I should say judicial warrant to go anywhere that is private, anywhere that is non-public. So they cannot come into my office or Adam's office or any of our conference rooms, definitely not into Adam's office, nowhere that the public is not invited to be. That is when they need the warrant. So I think that's an important distinction, is the public versus private space. If ICE shows up at your business and would like access to a non-public space and they do not have a warrant, you can tell them, no, you do not have to give consent. They need a warrant by law to access that space. Adam will talk about this in the next slide, but if they come with some other piece of paper that is not a valid judicial warrant, which we'll talk about more, you can also say, no, you do not have my consent to enter this space. And that takes a lot of bravery to say that. If you need a scapegoat, you can always blame the attorney. Everyone loves hating on the attorneys. So you can just say, sorry, my attorney told me this, and there you go. But if they come to you with a valid warrant, then a judicial warrant, then you need to review it. And as the slide says, that is issued by a court, signed by a judge, and it adequately describes either the place to be searched and or the items to be seized. And I'll let Adam go into the differences between a judicial warrant versus like an administrative warrant or something else in this next slide.
Thanks. So oftentimes, ICE, in fact, almost exclusively these days, ICE is only getting what is called a judicial warrant that is issued by the Department of Homeland Security. It is not signed by by a judge. It is usually signed by an ICE agent. So on the screen on the left, we have a sample judicial or a sample administrative warrant, sorry, that looks like it's giving them authority to come into your business. Some key features of this is that it's issued by the US Department of Homeland Security. It usually says warrant for arrest of alien on the top of it. And you'll notice that there's no place for a judge to sign. It says signed by an immigration officer. Um, and it does not have a whole lot of detail about what areas it is authorizing search of, what items it's authorizing the seizure of. On the right, you'll see a judicial warrant. And something that's very different about it is it says that it's issued by the United States District Court for, and then it'll usually say the Western District of Washington or whatever court it is being issued by. And at the bottom, it's signed by an actual judge. You can see that because it says judge right above the signature. So your first step is going to be assessing, is there an administrative warrant, which I can ignore, or is there a judicial warrant, which actually does give the law enforcement officials authorization to enter non-public spaces? And then just going back to Brianne's example of our office and the difference between the public spaces and the non-public spaces at our office. If we wanted to make our reception space a non-public space, we could lock our front door and only admit people who are our clients. And that would be a way to transition from what is currently a public space to a non-public space. And then Brianne's going to talk about what else is on a judicial warrant on the next slide.
So I've had this happen. Warrants have 2 pages. It has happened where the ICE officers have only showed up with one. It's like, where is the part about what you're going to search or seize? You need that. It is a deficient warrant if they don't have that. So as you can see on the slide, there is a whole page 2 that is really critical to a properly executed warrant. And that is the specific definition, like I said, of the inventory of the property taken, or it could be a person, or place searched. So read that. And if it says the Gibbs Houston Pauw office at this location can be searched, well, if we have another office down the street, that's not included. You can enforce the bounds of the warrant. The other thing that can come up sometimes is during an ICE raid, sometimes the officers will say something like, well, I'm just going to take these I-9s while I'm here. Going to get them anyways, we'll just take them now. No. If the I-9s are not listed on property to be seized, they may not take them. So you do want to, and hopefully, if your business is rated with a valid warrant, hopefully the list isn't too long of stuff to be seized or searched or arrested. But so hopefully you can really look at a very compartmentalized, tight list and keep the ICE officers focused and on track with the bounds of what they are allowed to be there for.
Oh, within that,
Oh yeah,
there also might, yeah, well, it's fine. Within that, there might be limits on where they can search. So if it says your warehouse, but it doesn't say your office space, they can't go into your office space. So be careful about limiting that. And I think that's what we're talking about on the next slide, anyways, is keeping them to the bounds of the warrant. So your main job is to just read it as narrowly as you possibly can, right? Your job is to try and exclude spaces from the warrant, exclude items from the warrant. Now, Brianne said they can't pick up a whole bunch of I-9s. Well, that's true. They can take anything that is obviously indicative of a crime that is in plain sight while they're otherwise executing a valid warrant. So if they come in and then they see a whole bunch of drugs lying around, well, you can't say, that's not listed on your warrant. You can't take those. But you can refuse to give them business records that aren't listed on the warrant because that's not obviously evidence of a crime. And even I-9s themselves, like improperly completed I-9s, are not criminal in their nature, and so there's no way, even if they were improperly filled out, that they would have any right to those documents. So you're going to be asking for a copy, reviewing it and making sure that you have somebody who is in charge of trying to limit their ability to access places or things that are not listed there. You're going to be trying to contact your attorney or activating one of the rapid response networks to try and get attorneys to the space as quickly as possible. And if at all possible, at a place of employment, we want to try and secure things that are not covered by the warrant. Have your employees turn off their computers. You don't want ICE to just be able to get access to all of your documents because your computers happen to be on. Lock any doors that you have that will seal off spaces because you can always unlock them, but you basically can't get the genie back in the bottle if they gain access to a place. And so having a policy where ICE is here, let's secure our facility, everybody turn off your computers, lock any unlocked doors, and then we'll comply with the warrant. Your business for the day is likely over. And so what you need to do is focus on responding to this in the best possible way.
Mhm. And one more point on that, I mean, if it is confusing at all, you think an ICE officer might not understand where the boundary of your public versus private space starts and stops, put a sign up, employees only. Like Adam said, we could make the business decision to lock our doors and have a code, or you can do things to help distinguish those boundaries. Just, signage is always helpful because then it's very clear. Like employee only is not a public space. So, okay. So if there's no warrant, like, you can say, I don't consent to the search. If there is an administrative warrant, that's not good enough here. You can say, I don't consent, go home, ICE. If there is a valid judicial warrant and you've reviewed and you think, uh-oh, I think this is legitimate, you can't stop it. You need to allow the officers to execute the warrant. The last thing you want to do is interfere or obstruct a federal investigation. You don't want to tell employees to hide. You don't want to tell employees to run. You absolutely want to help if you can. Keep ICE to, if it says we're here to search the milking barn, okay, funnel them to the milking barn and ignore, help them find where they need to go without showing them other places of the business. While the search and seizure is happening, it can be a lot. There's usually a good number of officers that are on the premises, and they all have a specific job. Some people are going to be searching areas for whatever is listed in the warrant. Some people are going to be taking pictures. Some people are going to probably try to interview workers, separate workers, have people go to certain spaces where they can ask them questions. It's going to be a lot, and you're not going to be able to interfere. But hopefully you will have a plan that would enable you to have a certain number of managers or leaders who can help follow, I guess, or document and make sure that the search is being conducted appropriately. And that, like Adam has mentioned, that you're taking good notes, that you're witnessing and trying to stand up for the rights of your business and your employees to the extent that you can, while also not interfering with the federal investigation. Adam, do you have anything to add about that?
No, I think that the note taking is also going to be hard. I would usually recommend that you designate one person to
Yeah,
be reading the warrant and trying
yeah,
to construe it as narrowly as possible, and one person who's taking notes about what's going on.
yeah.
Um, Oftentimes, recording is a really good thing. So, bringing out your phone and just taking a recording of the whole thing or a GoPro and just say, I'm recording this for our benefit. Um, they often do not like that and will try and dissuade you from recording. And so, you have to use your best judgment on the way that you can effectively do that. Having some passive cameras that are always on is really helpful in those circumstances. But if they're being super aggressive and taking your phone away, then just start writing things down. They
Hmm.
take away your notepads, which they can or they can't legally do that, but they may end up doing that. Take notes immediately after it's over so that it's fresh in your mind and you don't forget something.
Yeah.
Um, that would be my comment on that.
Yeah. And maybe one more thing to add, who knows how much ICE would listen to this, but if there are specific safety needs, employee needs, production needs, something about your business that you think needs to be communicated to ICE, because these searches can be lengthy. It can take a good amount of time. So if you know you've got an employee who needs to take medication, or employees who need to pick up their kids, or if there's machinery that, I don't know, needs to, you can't really turn off, or if there's some concern, make sure you advocate for your employees and your business needs with whoever is in charge of the investigation.
Yeah, that's on our next slide
Oh,
about
is
some of the
it?
things. Yeah.
Sorry. Well, let's go there. Um,
So here are some good concrete steps that you can take. And we've kind of tried to break this into employer actions versus employees. So if we go back one, sorry, you advanced twice, I think.
Whoops.
Yeah.
Okay.
We've talked about these as we've been going through, but designate your point of contact who has the script and knows what they're supposed to do. We always want to ask ICE if your employees are free to leave. And if they say no, that is officially a seizure of their persons. So that triggers a lot of our constitutional rights if people are not free to leave. As Brienne mentioned, try and document, if you have a pregnant person or a nursing, somebody
Yeah.
who's nursing or somebody who's protected by the ADA, you would
Mhm.
want to communicate those things to the officers and ask that those people be given, whatever it is that they need to maintain their health, care for their family. We definitely want you to be calling your business lawyer if you have one, or an immigration lawyer, or a rapid response network, because you don't want to be trying to do this on your own. And then generally, we want employers to have a way of notifying family members of what's going on. One of the best things you can do is try and be an advocate for your employees by at least getting some information to their family so that they can be prepared.
Mhm.
And then we want you to try and limit access. Like Brienne said, they will often ignore you. Like I mentioned, they will often try and abuse their power because there are very few things we as lawyers can do to correct it if they don't follow the law. Really, they're trying to get people into deportation proceedings and they don't care whether they violate your rights. But document that stuff because you may have the ability to sue them after the fact for damages if they're violating constitutional rights or, engaging in criminal activity or, tortious activity that's like beating people up or harming your business that's not authorized by the warrant. What you should not do is aid your employees in escaping, right? You can't hide people or, secret them away. That is a federal crime. And that may cause things to get worse for you. You can strictly enforce the limits of the warrant, but we don't want employees or employers taking their employees in their personal cars and driving them away, or creating hiding spaces within the places to be searched, because that can open you up to criminal liability. But what you can do is remind your employees that they all have constitutional rights to remain silent, and that just because law enforcement is here, that does not mean that they have to answer any or all of their questions, particularly if they don't have a warrant for arresting the person that they're trying to question.
All right.
So
Oh,
now
sorry.
we're gonna no, that's it. I was gonna go on to the employee stuff. So you're up.
Perfect. And I'm just going to say, Gina, I am not getting, I don't see the pings for time. So if we're running close on time, if someone can just say it, that would be great.
Sorry, can you repeat that again?
Yeah, I'm just asking our timekeepers,
Oh,
I'm not getting messages. So if,
oh, that
yeah.
means you're doing great. No, you're on time.
Okay, but I won't see them. So when they come is what I'm saying, let me know.
Oh, all right. Thank you.
Yeah. So this slide is really about your employees' rights. And as Adam mentioned, we are doing another presentation in a few weeks geared towards employees. But it is important for you to have an understanding of what their rights are. And primarily, it's the right to remain silent. They do not have to talk to ICE, and in fact, should not talk to ICE. As the slide says, ICE is not your friend. Usually, what we recommend is people say, I would like, I'm invoking my right to silence, or I would like to speak with an attorney. I'm invoking my right to silence, something like that. We definitely would recommend, it's never a good idea to carry fake or fraudulent documentation. As Adam mentioned, it's not a good idea to run or hide. Make sure that employees have locked all, their phones or any devices, and that ICE can't access that without a warrant. And employees shouldn't sign anything, definitely, until they've spoken to an attorney or had an attorney review. So the biggest thing is for employees just to invoke their right to silence and know that they have the power to do that, to not communicate with ICE.
So some things that you may see ICE officers do, and this is not an exclusive list, this is just a fun sprinkling of some of their common tactics. They may threaten you as an employer to audit your I-9s, which can come with serious fines. Claim that you have no right to see their warrant, that they're there as law enforcement. Present deficient warrants, as we've described. Present an administrative warrant and claim that it gives them access to your entire facility. Try to be your friend. Say, we know that you're in violation of a lot of laws, but if you just let us come in, we'll make sure you don't have any problems. That's a lie. They will, this is more for the employees, but they'll try and get people to engage in behavior that identifies them as foreign nationals, like say everybody with a green card move onto this side of the room, everybody who has a work permit come stand over here. That is technically speech, right? Like that is engaging in things that people aren't required to do, right? That identifies their nationality without them talking, and we would encourage people to not fall for that tactic. um, you know, Ask everyone with TPS, everybody with TPS, please raise your hand, right? These are all tricks because you don't have any problem maintaining your silence. And in fact, the only thing ICE often needs to do in order to put somebody in deportation proceedings is just establish that they weren't born in the United States. That's it. And so if they say everybody who doesn't have a green card, raise your hand, or everybody who's not a United States citizen, raise your hand, you've done all the hard work for them if you raise your hand. And we'll be talking to employees more about this, but trying to educate your employees about these coercive tactics in advance is pretty helpful.
And I will add, I did have an example where the ICE officer, the business owner said, "Do you have a warrant?" And the ICE officer's response was, "Yes, but we'll give it to you at the end." It was like, "No." And so they did. They did this whole search and seizure, and then at the end served a deficient warrant. It was like, up front, you must take that warrant up front. All sorts of tactics. One thing that can be helpful is bystanders. Um, this is basically someone who can film, like with their phone, what ICE is doing, what's happening as they're entering your business and what they're saying, what they're doing. The hope is that if they're on video, they will behave themselves. And I think that that can be true. Can be true. So you do have a First Amendment right to record law enforcement in a public space. In a private space, it's up to the owner of that private space if you can video, but I would assume if you're the employer, you would be up for that. As Adam mentioned before, ICE does not enjoy being videoed. So they might get mad about that. I think it's a good idea in a raid response plan to assign someone to record and be the bystander. So that person needs to stay calm, not interfere at all, keep a safe distance, and basically just observe and document. The person recording can narrate if they want and feel comfortable doing that. But definitely don't yell at the ICE officer. Just say, I'm recording, I'm recording this interaction, and then narrate as it goes, but make sure you keep your distance. That can be really helpful to attorneys after a raid is concluded in really seeing what happened, if there were any constitutional rights violated, and if we have any arguments for suppression of evidence or anything that can help people or the business owner. Adam, do you want to add anything on the bystander stuff?
I would just say ICE is usually trying to escalate, right? They're not trained in
Yeah.
de-escalating situations. And
Yeah.
so trying to, if anybody's ever attended any trainings on, protest and de-escalation while actively protesting, you really want to implement those tactics, never stepping towards the officers, always, retreating. If they get up into your space, you can stand ground, but you never want to advance on somebody who is trying to escalate because they want to get into a confrontation that will allow them to arrest you. And so, as a bystander, if that's your role, you are in a de-escalation mode and a documentation mode rather than an active fighting mode, right? Your only goal is to document and observe. And whatever way you can do that, it's going to be helpful.
Perfect. Thank you.
So, what have we talked about? Main things are have a plan, practice your plan, right? We're going to do a ICE raid drill. Make sure that everybody knows what to do and what to expect. Because if you freak out, you're going to make mistakes and you only get one chance. So, second you make a mistake, don't worry about it, but get back onto your plan, right? Checklists are super helpful. We're always asking for the warrant. That's going to be your number one defense because almost exclusively they don't do it. right?
Or they do
Like
it
just
wrong.
or they or they
They're
do it
sloppy.
wrong. Um, so if you can get them on a technicality, get them on a technicality. You don't have the proper documentation. Then we go into asserting the rights that we do have and documenting what's happening. We're not stopping them from, actively um, searching and seizing things that are described in an actual judicial warrant. That's against the law. Um, you're not interfering or hiding or helping people escape, but you are advocating for your employees and your business. Just, you're not a potted plant while this all happens, hiding in the corner, trying to call somebody and yelling about how unjust it is. You've got an active role, and that's to assert your rights, limit the scope, and remain calm. And try and help anybody that, actively needs help. If this person's a US citizen, here's their passport. They need to go and pick up their child with Down syndrome. No.
Yeah, right.
Just jumping in to give a quick time check, around 15 minutes.
Oh, thank
Okay.
you. That's what I was looking for, Kat. Thank you.
I got you.
Yay. Okay. And then I was going to add to that, Adam. I think when we think about raid response planning and training, people think a lot about training the trainers, train the manager, set a plan for the top level who has to deal with ICE if they show up. But it's also really important that your employees know their role too. And one of their most important roles is to not say anything. It can absolutely happen that the first person that ICE bumps into on the way into your business is an employee who consents to that, like who does something that would make ICE reasonably think that they have permission to enter and come in. So employees also need to be involved in that plan and told that their response should be, I don't have authority to talk to you. You need to you need to talk to Adam Boyd, our managing partner. So just a reminder there. And then wanted to rope in a little bit of state law into our federal conversation. Some of you or all of you may have heard about the Immigrant Worker Protection Act, which just recently passed and is going to be coming into law here June 11th and kind of trickling in to a law that is also coming into effect October 1st. There's some phases there. This is designed to provide more transparency to immigrants in the workforce, where when it comes to federal immigration agencies interacting with their place of business, their employer's place of business where they work. So some of the key provisions of this new law are, one, if your business is audited by ICE, you must tell your employees, all of your employees, within 5 business days that you are under I-9 audit. There's a specific poster, like some information that you have to put up on your business, and that exact information, what you need to say, it needs to be made available in English and then the 5 most common languages in Washington State. And the text of that information is going to be available from the Attorney General's office by September. So basically, one of the main purposes of the law is keeping your employees informed when immigration is snooping around in the immigration records, so that employees have notice if they need to get any of their documents in line or ask questions of their own counsel. And then there's 2 other parts that I think are worthy of mentioning. One is once that, and we'll be talking about ICE audits here in just a second, but after ICE gets back to you with the results of that audit, if they find these 20 employees' documents don't check out, under this law, you have a responsibility of informing those 20 employees. Before this law, you didn't have, like, well, you do have to tell them, but you have an obligation to communicate and notify the employees and have a meeting, provide information. So there's going to be some additional requirements for the employer, but only in the event of an ICE audit is this stuff triggered. So keep that in mind. There's also a non-retaliation, no anti-discrimination or no discrimination. You can't retaliate against employees for asserting rights under this law. This doesn't change, it doesn't stop a federal immigration enforcement. It doesn't eliminate your requirement to respond to the I-9 audit, and we'll talk about that in just a few minutes. Right now.
Well, yeah, right now.
Right
We're
now,
going
we'll
into
talk
it.
about that.
So, we've been talking about raids, and at the very beginning, I said that raids aren't typically associated with I-9 audits, and that's because they happen in very different ways. I-9 audits are more about paperwork and documentation rather than police showing up in force and questioning you and your employees. And it's still an immigration enforcement tool. What we're going to talk about is the typical time frame of an ICE audit or an I-9 audit and what you can expect at each stage. So let's jump into it because we've only got about 10 minutes.
Yeah. Do you mind if I'm going to do a quick overview of that. Is that okay? Just for the sake of
Yeah,
time.
of course.
So we don't have a separate slide, but I think it's important, as Adam mentioned, to understand that I-9 audits are different from a raid. This is about the paperwork, at least initially. So rather than a busload of immigration officials showing up at your business, one or two will show up and they should identify themselves and ask to speak to the owner or the manager on duty, and we'll let you know that they are with Homeland Security Investigations or ICE, and they are here to serve you with what's called a notice of inspection. And that is the official name of the piece of paper document that says we are auditing your I-9s. And the I-9 is the piece of paper that you fill out for all of your employees to give them, that verifies their identity and their employment authorization in the United States. That notice of inspection by law will give you 3 business days to turn over your I-9s, and they always ask for more. A few other documents like payroll records, an employee list. It will also tell you this period of time that you need to turn over the records for. For example, all of your current employees and terminated employees for the past 1 year, 2 years, 3 years, whatever that window is. Officers almost always will so helpfully say, "I'm happy to wait if you would like to turn over your records now." Of course, that is a trap. You should never do that. Always, always take your 3 days, your 3 business days, and involve your immigration counsel to help you put together what information you are turning over in response to this audit. Once your stuff is, your attorney, if you have one, can also ask for an extension of those 3 business days because it can go fast if you're not organized. So if you don't know where your I-9s are, now is a warning to get organized. Once the records are turned over, ICE will review them and then will come back to you with any number of, there's a variety of things they can send back to you. Either saying, "These look great, no fine, you're in compliance," saying documents don't check out for these employees, or saying, "Here's all the violations to your paperwork." Those are kind of some of the most common responses. How quickly they get back to you is anybody's guess. Some seem to go fast, some seem to take forever. but then they tell you what they need, like correct these I-9s or ask this employee for different documents their records aren't clearing, and then you go back and forth with your attorney to respond and proceed through the audit to the end, where you are either said, great, thanks, you're in compliance, or you are informed of the fine that you must pay. Sorry, that was a little bit long-winded, but I wanted to.
Nope, it's good. It's good to give the overview because we might not get through all of this.
Yeah, no, we're not. Yeah, we're gonna get through perfectly through the end of the I-9 audit stuff. So,
Okay. All right.
yeah, just what we planned.
So, as Brianne mentioned, you're given 3 days to turn over the I-9s, and you can either do that by having them come and pick them up, or you can go to their office and surrender the I-9s. And they're going to want the physical forms, or if you are in compliance with electronic documentation, the actual records that you're keeping. For all of the other documentation that is part of the search, you can request an extension. So payroll records, business records, they will almost always give you an extension to produce those documents. You can't assume that that's going to happen, but you can request an extension for everything other than the I-9s themselves. And we would typically do that because it takes time to collect some of that other stuff. But you're supposed to maintain the I-9s in a readily available format.
And no warrant, right? Did you say that?
Yeah, no warrant.
No warrant is needed to come and hand you this notice of inspection document. So usually cases are different, but usually there's actually two documents that you're given. One is the notice of inspection, which says, I want your I-9s. And then the second is what's called a subpoena. And that is a document that usually asks for you to turn over more stuff. And that could be anything from tax records, business records, information about business owners, copies of prior immigration applications if you've sponsored H-1B, H-2B, or done perm for any of your workers, definitely the payroll records. That varies depending on the business and what HSI and ICE are looking for. But usually there's two documents. Often, I mean, and the request can be quite big and detailed. So, yeah.
Here's no spider web of possible solutions.
That is from the department, I think HSI's website. This is their explanation of the
Simple.
process.
I'm not going to go through the entire flow chart,
No,
but
don't. The point is it's complicated, right? The point is there's a lot of different ways this can go, and this is, yeah.
we definitely recommend that you get legal counsel at least at if not at the initial service when you're sending over the documents on the subpoena. It's helpful to have somebody review that, because the main power as an employer is, just like with an ICE raid, limiting the scope of the documents that you have to produce. You never want to produce more than what is required. So
Yeah.
that's my main takeaway from this complicated spider web.
Yeah, I think that's fair. And that gives us some time to talk about the fines. So, not to scare anybody, but kind of to at least put you on notice, it's expensive. These I-9 fines are pretty steep and they go up every year with inflation. So, the paperwork fines range from $288 to $2,861 per violation. And the way that the fines are calculated is actually pretty complicated, but I think the simplest way to say is they review all of your I-9s, and if you have a very small number of I-9s that have errors, they set a base fine that's going to be less, closer to that 288 range. But if like 100% of your I-9s or 80% of your I-9s have errors in them, your base fine per form is going to be closer to that 2,861 number. So it is very, very beneficial to do a good job on your paperwork so that you can lower that base fine amount. It adds up incredibly quickly, especially when you think that they can audit all of your current workforce plus all of your terminated employees for however long, however many years back they choose to ask you for. Wouldn't be more than 3, but um, still, that can be a lot. So it's definitely worth doing an affirmative I-9 audit yourself to make sure that you're being really careful and you're correcting any errors that exist right now. Adam, do you want to add anything about forms? And then we have 2
I
minutes.
would say
Any fines?
destroy what or about fines, you can often get them reduced if you challenge them through the legal
Yes.
process.
Yes.
You don't necessarily need to accept their
No.
maximum fine as a
No.
final. And then reiterating the affirmative audit process is important. You need to be getting rid of documents that you're legally entitled to get rid of, so you don't accidentally send them over in an audit. That's one of the best things that you can do, in addition to making sure that everything is corrected that might have had an error in it.
Absolutely. Nothing is more sad than watching someone get fined for records that should have been purged and could have been
Yeah.
purged. Like, oh,
Hmm.
yeah, that's a bummer. This is our last slide, and we are going to come in right on time. So just a few months ago in March, ICE decided to update what is defined as a substantive versus a technical violation on the I-9s. There hasn't been an update in basically 30 years. So this was a big deal for those of us who do I-9 audits. Um, Technical errors, you're allowed to correct. So, if you make a mistake that's a technical error and you get audited, you have a period of time that you can fix it and there's no fine. Substantive errors are you're fined for those. So the takeaway of their new update is now almost everything is a substantive error. Very few technical errors are left. So it is going to be even more important. Now, more is finable automatically to do those affirmative I-9 audits. Yeah, anything on that, Adam? Anything you want to
Nope.
add? Or?
No, we did it. We're 1 minute over.
We did it. 27 seconds over.
You two are a rock star, definitely on time. Really
On time.
appreciate everything all you have done. So we're gonna go into our question section. But before we do that, let's thank the trainers for the presentation by giving them a round of applause. If you can click reaction, there's a clapping hands. If you can do that for them, that'll be awesome.
Oh, thank you.
Thank you.
Yeah, thank you.
Hearts are encouraged as well. They have been great and been on time for today's training.
Yeah.
So we're gonna go into Q&A. Please ask questions that are not case specific and do not provide any personal information. Raise hand if you would like to ask your question out loud, or put your questions in the Q&A below. Especially if you want to ask question in Spanish, Oromo, or Amharic, please raise your hands. Interpreters, please let us know if you received question in language, and our tech support will be there to support you all. So interpreters, if you get questions, please click raise your hand. So till then, I'm going to go ahead and start reading the questions that were in the Q&A section. So the first question we have is, there has been warnings regarding ICE at the Pike Place Market where I work, which is why I joined this seminar. I don't carry my passport with me, which contained my visa. I have a picture of it in my phone in case I need to show it. So if I encounter an ICE officer, what do I need to have present to prove my legality?
So You actually don't need to constantly carry around documents to prove that you're legally in the country, because if an ICE officer approaches you in public, you don't have to respond to their questions. If they're asking you, where were you born? You don't have to respond to that. You can provide them with, they can ask what your name is. And if you have ID, if you have a driver's license, you can present that. But what we would recommend is that you just not engage with them if at all possible. You would say, do you have a warrant for my arrest? Am I free to leave? I'm gonna I'm gonna leave. I'm not answering any questions without a lawyer present. And that would be the end of it. They should accept, any electronic documentation showing that you are lawfully in the country, but I also wouldn't advise you to be opening up your phone
Yeah.
to show it to ICE, because then that might give them access to the contents of your phone. And so if you're really worried about that, you can take a screen grab of it and keep it as your like landing page on your phone. But make sure you disable biometric unlocking of your phone so they can't just hold it up to your face and unlock it. But the best would be just like a printout in your pocket. So my first step would be don't engage. If they don't accept that, having a printout of your documentation would be better than an electronic copy in your phone, just because I wouldn't want them to get access to the phone.
Thank you. And just want to give you heads up, we have 12 questions. I'm sorry, 13 questions. And so we got a good number of folks asking pretty great questions. So the second one is, even if we, a non-attorney staff, are presented with a warrant or document, can we require the agents to wait outside the office, private areas, until an attorney comes to verify the nature of the warrant, whether they're truly judicial or administrative?
That's a great question.
It is.
I'll share my thoughts, and Adam, you can pipe in if you have different thoughts. So I don't think you can have them wait. They're allowed in public spaces, right? So I think they're not going to like go outside. So if they're already in your reception area or whatever, I think you can keep them there. I think you are entitled to ask for a reasonable amount of time to review the warrant. And I would recommend asking for that. The question is, what is reasonable? Waiting for an attorney to come they're not going to wait for that. But if someone can take pictures of the warrant, and send it to an attorney, that's what I would try to do. Try to get someone who has some legal knowledge to help you review it quickly. I would think they would, what, you think 5-10 minutes? I mean, that's reasonable. Maybe they're going to be pushy.
I 100% agree. It's like a law school hypothetical, because yes, you can ask them to wait while you verify, but then the key thing is wait for an attorney to show up. No. And so you're well within your rights to say, not refusing to comply with a valid warrant. I'm just making sure that everything is on the up and up, and I just want to run it by our legal counsel. And yeah, I think you're getting beyond 10 minutes. It's probably too much of a delay, but I would reinforce, like, we're not refusing to comply. I just want to verify.
Okay, the third question is, what if the judicial warrant is for the wrong address?
Those are the best.
Go away. Go to that address. Sorry, bud.
Yep.
Wrong place.
Wrong address.
Try again.
Yep. You can refuse consent. Very clear. Yep. Wrong address.
Okay, that's a great answer. The fourth question is, can the judicial warrant be intentionally vague? like authorized to search every single private area within the business or similar?
No, this actually, sorry, Brianne, I think this one's yours.
No,
If you
yeah,
want. This
you
one
can go
goes
ahead.
back. This one goes back to the Fourth Amendment, and the judicial warrants actually have to adequately describe the items to be searched and the places to be seized. And if they are overly broad or vague, deliberately so, it is technically an invalid warrant. And if you saw something like that, you would want your attorney to immediately challenge it in court. It's likely not going to stop them trying to execute it when it's presented, but you would want somebody going back to that judge saying, like, what did you do? Right? The judges shouldn't approve something like that.
Right.
But if you saw something like that, it would be something that would be ripe for challenge in court.
Mhm. There should be specificity with what they are searching. Mhm.
Great. Before I go to the next question, if folks have questions they want to ask out loud, just leave your hand up and then I'll get to you all once we finish these questions. The fifth question I have is, what happens if the independent contractor or worker place of work is field work?
Mm.
Like agriculture field work?
That's a great.
No, it's not. Sorry, I'm just gonna step in here, Gina, and I'll try to speak slowly. It's actually more like turf or organizing, or is their primary area of work is not a point of sale. It is an movement or an app worker,
Okay, so
Mm.
driver.
the person is out in public, basically.
Yeah, their place of work is basically their body, and their movement.
Those are tougher.
So a car is a private space. So I would say if it's like a Uber driver or a gig worker that is using their own personal vehicle, that is a good private space to maintain. Um, but if you're in public, you are subject, you don't have a reasonable expectation of privacy. Um, and if ICE has a warrant for your arrest and you're in public, they can arrest you. So it would go back to just maintaining your rights to remain silent. Like people feel like if they have documents, they want to present them. Your best bet is to just say nothing. Even if you have documents, just say nothing. And if they have a warrant for your arrest, they're going to arrest you. Say, am I free to leave? And I'm exercising my right to remain silent. And that's it.
Right.
But it's
You
not
can
really,
refuse consent of searching a car
yeah.
to go to piggyback on Adam's comment. So you can assert that. And again, just asking if you're pull over safely, ask if you're free to leave, refuse a search. If they don't have a warrant or if you didn't violate a law, you should be free to leave. Just exercise your right to remain silent. But it is trickier because you don't have that public space in the same way as other places of employment. Yeah.
Well, and ICE often doesn't recognize those private spaces. They'll
Right.
break car windows and drag
Yeah.
people out.
Right.
So it's a little bit scarier and harder to maintain that, but you would want somebody to assert their rights to maintain their privacy.
Yeah.
Okay, moving a little bit quicker. Sixth question. Can ICE stop business from serving customers or doing businesses during a raid?
No, unless it's interfering with the execution of the warrant, you can maintain, your business. It may be difficult because you might not be free to move around.
Yeah.
It's a weird line to cross. I find it hard to imagine that you'd be insisting on doing business during that process or that you'd be getting a lot of customers or anything. It's more about maintaining safety. If there's equipment that needs to be, maintained in a specific way, you can't just, shut it off right away. I would be thinking about things like that rather than continuing to serve the public.
Yeah, it's not very practical. Everything is going to be commandeered by the ICE investigation. So yeah, I think business would stop.
Okay, for next question, I do wanted to give opportunity those who want to ask the question in Spanish, Oromo, or Amharic. If you have questions, please raise your hand. Okay, sounds like I'm not seeing any hands. So I'll go to the next, and I'll check in a couple times with you all on that. The next question is, for seventh question, is if the agents ask me, non-attorney staff, questions, do I have right to refuse to reply until our attorney is present?
Absolutely.
Yep.
Have an absolute right to remain silent.
Okay.
And we would recommend you do that. It's this like the 2-year-old treatment. I ask my son a question and he just doesn't respond. That's the best thing that you can possibly do.
Okay. The eighth question, do you have a First Amendment right as a non-citizen? And this came in during the part about recording ICE.
Yes. Sorry, I keep answering the questions.
It's
Go
okay.
ahead.
You're doing great. I'm piping in.
Everybody inside the United States has a First Amendment right, whether you're a citizen or not. It gets tricky if you're at the border, right, trying to get admission into the country. But while you're here, if we're talking about the context of like an ICE raid of a physical employment space, you definitely have a First Amendment right to record, to remain silent, to yell at them if you want, although I wouldn't necessarily recommend that. But you are protected by the Constitution.
The ninth question is, there are city policies and signage stating that ice staging can't occur in Seattle city parks, but these spaces still don't have the same protection as private property. Any advice specific to how to respond or protect employees in public spaces such as parks?
Go, Brienne. I'm going to let you.
Yeah, I mean, I was gonna say it again to remember employees should always remember their right to silence. They should carry, if they have know your rights cards or, little helpful if someone's scared where they can just hand a card to an officer. Employees should have their safety plans in place. It's hard because if you're in public, you're in public. There's not much you can do you're putting yourself out there in a non-private space. So if ICE has a warrant for your arrest in that space, it's valid. I mean, do you have a different suggestion, Adam, for how?
Well, I agree that, it doesn't carry the same protections. I would be contacting the police to notify them if ICE is violating that and using the public spaces as a staging area or engaging in civil immigration enforcement in public spaces, because you're correct. The city has designated all city spaces as not available for that. But agree that if they're going to arrest you and you're in like a public space, then there's not much you're going to do to stop it. The best thing you can do is try to remain silent so that we could potentially suppress any evidence that is obtained as a result of their violations of those ordinances or laws.
Yeah.
Okay, the 10th question is, I-9 audit, when required, turn over original documents, or can I do copies? Worried they'll lose the originals and then I'll have nothing. Can I keep copies? Will those be valid in the future if another audit came?
Yeah, I can take that question. Um, I usually turn over originals for employers who keep physical paper I-9 records. But you're not, some employers who keep digital I-9s, you're actually allowed to purge the original I-9 if you have a digital copy. So there's not necessarily, depending on how can be a complicated answer, but it's okay if you have originals and you should make copies 100% before you turn them over in an audit, but it's okay if you don't get those back if you have the copies and they were confiscated through an ICE audit.
It's also unnerving because it can be a long time before you get the originals back,
Like,
like
yeah, you should I mean, obviously you make a copy of everything that you turn over, and I should give you a receipt when they do audits of everything that you give them. And so there's that record as well.
and it's usually two receipts. They'll give you a generic receipt when they first seize the documents, and then a much more specific receipt within a couple of days, usually.
Okay. Before I move on to the next question, just wanted to ask again for those who are in interpretation rooms, if you have any questions in language other than English, please raise your hand and we're happy to get those answered as well. Okay, the 12th question that I have is one concern coming from our community, including is around driver license information and data privacy. Washington State Washington working law limits state agencies from collecting or sharing immigration-related information. However, community members are still worried about whether federal agency can access DNV or Department of Licensing records if they already have a person's name or identifying information. Our question is, what protection currently exists to prevent misuse of DOL information, and what accountability measures are in place if community members believe data is improperly accessed or used to target immigrant communities? That was a long question. Let me know if you want me to repeat it.
No, I've been reading along with you. So unless the state provides direct access to their databases,
Yeah.
federal officials shouldn't have access to them. And if people believe that federal officials are getting access to the state documents, I think that would be a referral to the Attorney General and to state officials to investigate how that's happening.
Mhm.
As for the security measures, that's really kind of outside of my scope, because that's a state maintained system and we are private attorneys. So I don't know what steps this state has taken to secure that information. But generally, if immigration has information about you, it doesn't really matter what's in the Department of Licensing system unless they're trying to get like your current address.
Okay, 13th question. We got a notice about Social Security number mismatch. We have informed the employee to contact the Department of Social Security to inquire. What else are we required to do?
So first, I would suggest that people, not assume that the employee is not authorized to work. There's lots of reasons for mismatches. So when you get that notification, there's different varieties. So make sure you read exactly what the notice is telling you and what the mismatch is. Confirm with your records to see if it's a typo on your end or if it's an easily fixable thing like that. If it is not, if you have checked your records and you didn't make a mistake, then you need to notify the employee, which it sounds like has happened, and give the employee a period of time. I typically say around 60 days to fix the issue. Um, I typically suggest that people check in with the employee if it hasn't been resolved at the 30-day mark, check in, let the employee know that it does need, at a certain point, it needs to be resolved, or it gives rise to an inference that they might not be employment authorized, and that gives you, as the employer, possible constructive knowledge that you may be employing someone without employment authorization, without valid employment authorization. And my position is that after 60 days, if it's unresolvable and the employee can't fix it and can't provide other documentation to establish employment authorization and eligibility, that their employment needs to be terminated. Do you have a different view, Adam?
No, that's
Unfortunately.
pretty much how I would approach it, unfortunately. Yeah.
Because if you don't, then in the event of an audit, you have been put on notice that this employee may not be employment authorized, and that can be a reference or an inference of constructive knowledge, and there's some hefty penalties for that, for knowingly employing someone who does not have authorization to work.
Okay, the next question is the 14th question is, can you walk us through what a good I-9 form looks like and all necessary parts that need to be filled out? If a I-9 form expires during someone's active employment, are they required to fill out the most current version I-9 form?
That's a lot. So the whole form needs to be filled out. As as to whether or not the form expires. So the form itself does not expire. You just need the form that was current on the date that the employee was first employed. If you're talking about expiration of their work authorization document, so that you have to re-verify, that you do have to do when somebody, for example, gets a new employment authorization card, or has a non-permanent type of employment authorization. Um, I would encourage you to look through the slides on the affirmative side of things, because that's asking what needs to be filled out, and what it looks like is longer than a quick answer to a question.
Yeah, so the I-9 form does get updated routinely, but as Adam said, the form needs to be the most current edition at the time of hire. You don't need to redo I-9s with the new version of the form when they come out. You only need to re-verify someone if their employment authorization has expired or will expire.
Maybe a easier question is, what are the mistakes they tend to find in I-9 audits?
All of them.
Oh, that's okay.
Yeah.
For a one-page form, it is crazy how easy it is to make mistakes. I think maybe I'll share my opinion, Adam, and you can share yours.
Yeah.
One thing I would tell employers is to not forget that, so section 1 is completed by the employee.
Yep.
Only the employee can put information in section 1. But the employer is liable for any errors in section 1. And often my employers don't ever check section 1. They don't ever review it. And you would be amazed at how much is wrong or missing in section 1. So just you have to check that section, especially now that everything is a substantive error. That's mine.
The other really tricky one is the handwriting is the same in section
Oh,
1 and section 2. So obviously the same person filled out section 1 and section 2. So
yeah. No, no.
um, y- you didn't comply. It was either the employee or the employer that did the whole thing, or the handwriting is different for the translator. um, and so obviously stupid little things like that are really frustrating, because it's not even like the form is filled out incorrectly, or the information is, or it's not that the information is wrong. It's just like you had one person complete the whole thing.
Hmm. Yeah. Sorry, there's lots of ways I-9s can go south, unfortunately, but
Good to know. Well, it sounds like everyone needs to make
go
sure
slow.
it's
Yeah.
Readable. Um,
Legible, yeah. Just take it seriously, I think is the takeaway. Yeah.
well, I have one more question left, and also just gonna ask again, folks, anybody, all languages, if you wanna ask question out loud or wanna add more question, now is the time, or raise your hand. The last question I have right now is the 15th question. We work with youth and family as well. What are you seeing as the long-term impact of this climate of fear on children, mental health, and community stability?
Can we end on a happy question?
I think we got one more person asking questions, so that might be happier than this one. So
Well, I don't think we've even begun to see the long-term effects, right? The actual terror is relatively new in terms of our immigration journey. Um, if I wanted to put a happy spin on it, I would say that the backlash to the authoritarianism is encouraging. The number of people that are coming out in the streets and protesting and being bystanders, and helping their community is really encouraging. But the trauma has been there for a long time. People have been scared for their parents for sometimes their whole lives.
Yeah.
Um, and it has a real impact.
Mhm.
So I, I don't know, maybe some psychologists can do a long-term study of it, and when we have a more accepting community, but it's rough. And if you know anybody who is in the immigrant community, know that they're probably scared, whether they're undocumented or not,
Yeah.
and try and have some compassion.
Hmm. I will say I've been really inspired by the grassroots community support and organizing that I've felt in our local community, and all the support that I've seen on the local level for our immigrant communities. And I'm hoping that's helping people feel like they belong here. But yeah, it's I worry too for the kids and the families right now.
okay, we have one person who raised their hand for a question. I will unmute you, and please make sure the question is nothing personal or sensitive information. Sylvia, you can unmute. Yes.
Yes, thank you. So regarding the mistakes, I want to just clarify. So, for example, if the employee in the part one doesn't put the numbers, let's say the USA numbers that have in the resident card, so that is a mistake that the employer has to pay. Thank you.
Yep. And to make it worse, only the employee can make corrections to Section 1. So for your current employees, if you do an audit and you find an error, you can have that person correct it. But for any of your terminated employees, those are now uncorrectable errors. And so in an I-9 audit, all of that is fined because you can't fix it. Only the employee can, which is why I feel that it is very important to review that section.
Thank you so much.
Yeah, I'm sorry. Wish I had happier news.
Okay, well, thank you so much for answering all the questions we got today. Just want to let folks know that the questions, we are not going to keep the recording. But just wanted to thank you all for asking in the question. We want to make sure that everyone feels safe today. But I want to give a round of applause to all our presenters, all the city's department, and especially our guest presenters from Gibbs Houston Pauw. So thank you all, and if you can, love the reactions that we're getting. I hope this training was helpful and informative for you all. We'll send out the recording and share the handouts and the presentation slides. So after this webinar, you'll see a survey. If you can fill that out, that'll be awesome. We hope to hear from you all and make sure that the next trainings that we do would be better than today. But if you have any questions after this, please feel free to reach out to me, and we'll make sure that we'll get you some sort of information or answers. But till again, thank you all for joining us. Thank you for all our presenters, and thank you for joining us today.